Good morning, everyone. It's so nice to see you. Today is September 16th, 2021, and our special speaker today is Ivan Derer, who is from a beautiful place in Canada, Alberta, Canada, Calgary to be exact. I've flown in there and spent some time in your fair province several times, and so it's a thrill to have you here with us. He will be speaking to us on the access to justice. But first, before we begin, Natalie, do you want to tell us the amount that has been raised so far, of which we know?
Gina, I would love to. Our community is doing so well for food banks worldwide. Last week alone, people let me know about $6,217 in donations just in that week's time. So our new total balance is $167,770 donated through these Will Work for Food presentations, which translates to give or take about 2 million meals that mediators, arbitrators, and attorneys have provided to our food insecure friends and neighbors around the world. Thank you all so much for your generosity.
That's just so fantastic. And as we want to make sure everyone knows, there is no charge for these programs. The speaker donates his or her time and talent, and all it is asked is that those who attend, if they're so inclined to make a donation to the speaker's food bank or charity that's mentioned, or to a food bank of your choice. And this is truly global, and this is just so fantastic. So today, the food bank for Mr. Derer is, let's see here, Natalie will put it in the chat, of course, Calgary Community Fridge, F-R-I-D-G-E, as in refrigerator. So Calgary Community Fridge, and Natalie will put the link in the chat. Now, to introduce Mr. Derer, as I understand it, he is a name that is well known, a person who is well known and respected in Canada, among the elite mediators, arbitrators, people who are in the field of private dispute resolution. And you noticed I said private dispute resolution, as he says on his website and all. That is what he looks at as the current name for what would formerly be known as alternative dispute resolution, ADR. So PDR, and I like that. Mr. Derer has been mediating and arbitrating matters for close to 40 years. He's had a diverse litigation and dispute resolution practice that spans the areas of insurance, professional negligence, construction, product liability, estate, personal injury, life and disability, matrimonial, family law matters, as well as, especially being in Calgary, high-end energy and commercial disputes. Since obtaining his LLM from Osgoode Hall Law School in ADR, his practice is now focused exclusively on being a mediator or arbitrator, and he has conducted over 3,000 mediations across Western Canada, as well as numerous arbitrations. And it is indeed an honor to have you with us today. So with that, let me turn it over to our esteemed speaker, Mr. Derer. The floor is yours, and maybe you can tell us a little bit about your food bank and then go on into your presentation. Thank you.
Thanks so much, Jean, and I will happily do that. So thank you, first of all, for your kind introduction, Jean, and also your complimentary words about my home province. Unfortunately, this morning we woke up to headlines here in Alberta about Alberta in crisis. So regrettably, we are a hot spot, as that term has come to be used in terms of COVID infections with this fourth wave. So that's very unfortunate. But I know that's a challenge to various degrees for most of us that are on this call. Good morning to everyone, afternoon, evening, as the case might be. I very much appreciate an opportunity like this to speak as part of this webinar series for Will Work for Food. Thanks to all of you, and I know I'm also joined this morning by some colleagues in Alberta. Thanks to all of you for taking time out of your busy schedules to be part of this program for the next hour or so. I started checking into this program about 6 or so months ago and have been consistently impressed with the caliber of speakers and insights they have shared about and related to the mediation practice. And I hope in the next hour I can make a modest contribution to what has been shared by others in the past. In keeping with tradition for introductory remarks, Jean, I am happy to share a few more words about the Calgary Community Fridge. It started at the outset of the COVID lockdown some 18 months ago. It's a small outdoor stand, which includes a fridge, freezer, and pantry. It's close to, it's in the neighborhood that my office is in. The organizers state that it's designed for Calgarians to take what they need and leave what they can. The concept is spreading to other neighborhoods. I'm sure it'll survive our eventual recovery from this COVID struggle that we're all facing. My wife, Julie, to give credit where it's due, bears the lion's share of responsibility between the two of us for keeping this pantry well stocked from week to week. So I appreciate any attention, any contributions that any of you might see fit to make to this cause, a very small neighborhood initiative that we have here in Calgary. I thought I'd start or resume my introductory remarks with just some geographic orientation for those of you that are joining us from far away. The province of Alberta is located just north of the state of Montana, and we have about 4 million occupants population here, and that half of that is split quite evenly between our two major cities of Calgary in the south and Edmonton in the north. And just a little bit more elaboration to what Jean kindly offered about my background. My practice is based in Calgary. Most of my retainers have been in Alberta, but I have served parties in dispute from Vancouver in the west through to Winnipeg in central Canada, and occasionally have ventured up to the far north in the Yukon. The original title for this talk that I proposed to Natalie some weeks ago was a Report from the Great White North. Predictably, that didn't get much traction, so we went with her suggestion, which is succinctly captures one of a number of topics related to mediation work that I have a very keen interest in. My observations and opinions are molded by my 40 years of practice, 25 years of which has involved a component of serving as mediator and arbitrator. And as Jean alluded to, I took a break or added to my workload some 15 years ago to get a master's in ADR, as it was then commonly known, from Osgoode. So for the last 10 or so years, I've essentially been full-time in practice as mediator and arbitrator. And most of my mediations involve parties in litigation and parties that are represented by counsel. And I just make that clear because we all know that there are a vast array of mediation settings, some involving litigation, others not, some involving represented parties and others not as well. My basic objective in my remarks this morning or today is to raise awareness about the significance of our work as counsel and mediators, how integral it is to the preservation and enhancing of access to quality justice, and ways in which we can do better, both established mediators and many who aspire to that field of practice, and along with the counsel who represent parties that are in dispute. The structure of my presentation, I'll continue talking for 35 to 40 minutes, Jean, as we talked about in advance. If there are some periodic questions or comments that anyone wants to share, Jean, I'll leave it up to you to table them with me. I'm happy to engage at any stage in any short discussion about any topics I might be covering. And hopefully there'll be a little bit of time left over at the end for questions and answers. I have a 20 set slide package assembled for this presentation, which Natalie has been kind enough to offer to run for me, so I can just focus on my comments and questions that might come up. Word of caution in connection with those slides that you'll see momentarily. I'm often teased for the wordiness of my slides, blogs, papers. It's often come up in discussions with Natalie as she helps me with my various branding and marketing needs. I'm acutely aware of the evolving trend in society for shorter communication as opposed to longer. And it's almost to the point, from my perspective, that it gives some meaning to the phrase of our famous modern day Canadian philosopher, Marshall McLuhan, the medium is the message. And in that spirit, I also wanted to pay a compliment to my oldest of 3 daughters, Caitlin, who is joining us today from her base in the UK. She's responsible for both the art and the layout of the slides. And she is a graphic designer and creative, as I said, based in the UK. And she does her professional work through an entity called Fancy Lamp. The slides are not only intended to provide some structure to my remarks today, but also as a resource of sorts after this presentation. So for anybody that might want a set of them, feel free to reach out to me by email. I'm sure Natalie and Jean will disseminate that information to you as part of this presentation. And I'm happy at any time, as my colleagues here in Calgary and Alberta know, to engage in discussions about any aspect of the mediation and private dispute resolution field. I also invite you to visit my website, which is also quite a substantive piece in comparison to many others. We have limited time today, so I will not be reviewing in detail every point on every slide, but rather just touch on major points from my perspective on most of them. And one final observation before I launch into the slides. I just thought I'd share this observation at the outset, which is that in my daily conversations with colleagues, in my daily travels from mediation to mediation, I rarely hear talk or sense much interest in the concepts that I'll be talking about today: the importance of trust in the process, access to justice in private dispute resolution context, standard of care analysis to performance of counsel and mediator, and ethical considerations that go along with our work as mediators. But I know, and I'm comfortable in assuming that for most of you, these are considerations that you well appreciate. So with that then, Natalie, if we could get the slides on the screen. And the first 2 are just preliminary introductory slides of both my firm and the title to today's presentation. And if we could just move the access to justice one up a bit, Natalie, thank you. So I'll just give you a moment to read this quote that's attributed to our current Chief Justice here in Canada, Justice Richard Wagner. And I thought this one, this quote very succinctly captured the breadth of access to justice, because as I'm sure some of you appreciate, whenever that term comes up, and it comes up often, it's often associated with ideas and concepts like accessibility of courthouse services, pro bono work, public interest initiatives, community legal clinics. But as most or all of us know, it's a much broader concept with deep application to private dispute resolution work, as described in the quote. The next slide is entitled Overview and Context. There we go. Thank you. So this is intended as just some brief background and context. As I point out in the first bullet, delivery of accessible access to justice. In the past, that was always in the domain of our courts and traditional litigation. But over time, and as most of you will appreciate, particularly over the past few decades, the appeal of traditional litigation, for reasons we need not belabor today, but generally cost, delays, risk, capacity on the part of the courts to process the ever-increasing volume of disputes, the appeal and relevance of our court system, and I think this is probably applicable based on conversations with some colleagues in the United States. It's applicable to the United States as much as it is to Canada. The appeal and relevance of our traditional court system has waned. And I then move on to talk about just a significant Supreme Court of Canada decision where our highest court confirmed and recognized this reality and endorsed both the support and the need for alternate adjudication of disputes. This is further confirmed, as I point out in this slide, by rules of procedure here in Alberta, and I'm quite certain that it's mirrored in similar rules of procedures in other jurisdictions. I also wanted to just make reference in connection with some historical context to the Pound Conference, which many of you will be familiar with. But that was a conference in the United States in 1976. Chief Justice of the United States, Warren Burger, at that conference was quoted as saying that, and he noted society's dissatisfaction with litigation as a dispute resolution process. He's quoted as having said that litigation is just too costly, too painful, too destructive, too inefficient for a truly civilized people. And so that's back in 1976. And I think it's also worth noting that that Pound Conference, based on all my reading, particularly in the context of ethics and codes of ethics, was really quite a pivotal point in terms of shifting the focus of many from traditional litigation to private dispute resolution, or ADR as it was commonly known in the past, and all sorts of considerations related to it, whether it be best practices or ethical considerations that ought to be kept in mind. So in my slide, at the end of this slide, I talk about JDR. I'm going to circle back to that right now. That was part of an initiative, certainly in Alberta, about 25 years ago. It got started up where some judges were assigned on a weekly basis to conduct mediations, judicial mediations, serve as mediators. And without elaborating on the pros and cons of that, I do make the observation here that there were limitations perceived by many of us in practice to that process, as well-intentioned as it may have been. And that, in my experience and observations, accelerated what I describe as the explosive shift to private dispute resolution platforms. So Natalie, if we could just go to the next slide now. There we go. Thank you. So this is where I start, and I won't belabor things as with most of the slides, but this is where I start some observations about some shortcomings to the JDR program, which have now been transposed into the private resolution field. But before I touch on some of the points on this slide, I do want, in fairness, to make a few preliminary comments. One of them is these observations are offered in a spirit of candor. They're intended to be constructive. No disrespect is intended to some of the ex-judges whose practices I might be on a no-names basis referencing. And it's not offered from a place of competition. I'm very, very fortunate to be booked months in advance with my practice. So this isn't about competition between those of us that work in the field. And nor am I suggesting that there isn't room for lots of different styles in the practice of mediation. In fact, in Alberta, the top half dozen mediators of the 30 or 40 that are aspiring to that work here in this province, they clearly understand, and I'm close to all of them, they clearly understand the fundamental aspects to our work, and they all bring very different styles to it. So there's lots of room for that, but there are some, as I describe them, incontrovertible principles to the practice of mediation, and most of you will be well familiar with those. And they're in the bottom right-hand corner of this slide to be remembered. So concepts like voluntary process, self-determination. And so back to the column on the left, these are common experiences that are shared with me by various counsel and parties, quite frankly, who are involved in mediations on a regular basis. These would be institutional parties. On my daily travels, there's lots of talk about people's experiences with mediation, what works, what doesn't work, who they've had experiences with as mediator. And these are common observations that are raised with me about experiences with the retired ex-judges that are operating in the private realm. And many of them mirror experiences that I and many others had as litigators when the JDR program was one of the only options available in Alberta for dispute resolution. So I won't go through those bullets, except, well, I'll just highlight a few of them. So, you know, it's quite common, and this is undoubtedly the experience of judges when they rule their courtroom, to dictate process, and are known to, on a regular basis, tell counsel at the outset of mediations how the process is going to unfold. It's been suggested, and I've watched a number of webinars by former judges recently, where they speak of advocacy being of limited value, not wanting to hear argument from counsel. And these are problematic and problematic disconnects, in my respectful view, with some of these so-called incontrovertible principles to mediation work. And you'll see in the top right-hand column, I've got a few bullets under style adopted, embraced by aspiring mediators and established mediators alike. And so I've got this one bullet, and why not? And what I meant by that is, on a regular basis, you know, I confront the experiences of counsel with some of the mediators that have this kind of approach. And I often have to remind them that my job as a mediator would be very, very easy and simple if I could show up each morning and tell everybody what process suits me, and tell everybody, in fact, what the right answer is to their dispute. And of course, I'm exaggerating some of those points, but the reality is that's not a mediation. When you consider and when you're thoughtful about some of these principles that I've alluded to. So not only do we have that influence from, you know, that originates with respect with the former judges, but it's also embraced by private mediators. And I can see a lot of appeal to it, because to be able to just show up and tell people what the process will be, and tell people in various ways what you think is a reasonable range in which they ought to be settling early on in the process, that does make the job of those at the head of the table quite easy. But I feel very strongly that that is not what a mediation should be all about. So next slide, Natalie, please. And then hopefully there can be some catch up with the slides. But the next page, I share once again comments and observations that are shared with me on a regular basis in my mediation travels. And they often relate to dissatisfaction on the part of counsel with how a mediation was run, dissatisfaction by clients with what their expectation might have been in terms of involvement in a mediation. And sometimes the reactions are, when there's somebody relatively new that is in the mediation field, that some or both counsel will say never again, or a roll of the eyes. And the reason I just highlight this is that these kind of observations, it causes confusion amongst many in terms of what a mediation ought to look like, what some of the important foundational principles are, and it also tends to chip away needlessly at the credibility of the field. And I'll return to that issue a little later on in my remarks. And then on that slide, if we can get it back, but of course it'll be available after this presentation. But I start to talk about some of the consequences to an unfortunate breadth of approaches that are brought to the mediation world. And one of them is and I have some context and perspective for this. For about 10 years in the recent past, I defended colleagues in this province who were sued by disgruntled clients. Typically, quite often, those kind of lawsuits arose from regrets over a settlement that the parties achieved. And quite often those settlements, and increasingly with time, they happen at or in the general context of a mediation. And so I can see the day now. I mean, there have been plenty of lawsuits in Alberta. I'm sure it's a similar situation across Canada and into the United States and other parts of the world, where the complaints of a client related to a settlement, for example, typically they're focused on their own counsel. But increasingly, I've noticed as cases get reported that there's more attention being paid to the mediator. And I think the day is coming, whether it's with regard to settlements or other disgruntled reasons for clients or for clients to have unhappiness over resolution, that the mediator is going to be the focus of attention as well. And one point that I had on that slide was it's a hypothetical scenario of questioning, which is part of our discovery process here in Alberta. So I just put out some points there about what counsel might be pressed about in connection with unhappiness on the part of a former client over a settlement achieved in a mediation context. And one of the questions which I expect to happen, and certainly even in my own experience, I'm starting to get approached to give standard of care opinions with respect to the work of mediators. One of the questions will be, to the extent you were guided by the evaluative input of a mediator, which is increasingly a popular aspect to mediation work, did you make any inquiries about the trial experience of that mediator? And that kind of question, we now have it up on the screen. So I'm on the right side of the slide, bottom bullet there. You and your clients were guided to some degree by a mediator with little or no trial experience. These are the kind of questions and due diligence that I maintain counsel ought to be more sensitive to, and we'll circle back to this momentarily in my remarks, in an effort, as I say in the bottom right there, it all adds up to avoidable problematic failure of counsel mediator to respect and promote right of access to quality justice. So the selection of the mediator, as I'll come back to in a couple of minutes, in my respectful view, is a very important component to this, and it's just not appreciated to the level it should be by most counsel. And I know that most of you appreciate these points and are alive to these issues. But part of my pitch to those of you that are established in a mediation practice is to respond to a call to action of sorts from my perspective in terms of trying to correct practices and trends that are not helpful for the future integrity of mediation work. So the next slide, Natalie, I'm sorry to put you to switching it again now that we've got this one on. There we go. Thank you. So on this slide, I capture three considerations that flow from my remarks just moments ago. So standard of care, all of you or most of you will be familiar with that concept. So that's the standard to which professionals, whether they be mediators, lawyers, engineers, etc., are held to. I make reference to the Adeshina decision because that happens to be still as I describe it, a recent foundational case of Madam Justice Sheila Martin. On a side note, that was one of a few highlights to my litigation career while I was still in the trenches doing it daily. Madam Justice Sheila Martin is now on the Supreme Court of Canada and very worthy of that appointment. But it was interesting in this case for a number of reasons. She went on for about 100 pages. It helps that she found in my favor. So of course, as a litigator, you're always a little more thankful and grateful for decisions that went in your favor. But interestingly, the lawyers that I was defending in that case, they got exonerated on every allegation against them, except for a brief lecture from the bench and reference in the decision. No damages flowed from it, but she was critical of some of the advocacy that the lawyers I was defending at the time embarked upon at one or more court applications. And I seize that as an example here where in the mediation context, whether it's in front of a former judge or a relatively new mediator who tells people what process they would like to have followed and a process they'll insist on. But when a mediator tells counsel that they don't think there's much value to advocacy, or they don't want a plenary session, or they don't want any argument, there's a fundamental disconnect with the obligation of counsel. And that's the main reason I'm highlighting Adeshina and other cases where, counsel need to be aware of their obligation to their clients. And if there's a mediator that is trying to impose process or deny an opportunity for an opening session, if that's the will of the parties and the will of counsel, or an opportunity to advocate, then you've got to stand up to that. It's your process. It's that of your client, not of a mediator to impose on anyone. And there are also code of conduct provisions. And I just quote a few of them from the Alberta Code of Conduct, which I'm sure are mirrored in many other jurisdictions. And then the standard of care and ethical considerations applied to mediators. So I've already touched on that. To date, there hasn't been much, if any, litigation worldwide involving allegations of negligence or substandard performance on the part of mediators resulting in litigation. Certainly not to my knowledge. I've read some articles, recent articles about that issue emanating from the United States, but it's coming. I'm quite certain it's coming. And, to date, many of the mediators will say, well, I've got protective language in my agreement. But the way contract law is headed, certainly in Canada, those kind of protections, number one, should not be your fallback position, that I'm protected against work as a mediator that might be viewed as substandard. But I'm sure the courts will find a way around that kind of language in certain circumstances. So next slide, please, Natalie. So triggers to erosion of trust in the process. So I'm not going to belabor these comments because I'm already halfway through my time here and we're probably about halfway through the slides. But my bullets there should be quite self-explanatory. But when you have a proactive mediator, whether it be an ex-judge or a private mediator that is emulating that style, one of my points here is it breeds laziness on the part of counsel. And so I've seen a pattern develop where many counsels seem quite comfortable selecting a mediator that is going to take charge because it takes a lot of responsibility as they view it off their hands. So just one example, in some mediations now, when I inquire at the outset about what kind of process the parties would like, increasingly they're saying, well, can we dispense with an opening? And my brief speaks for itself. And those kind of openings from counsel strike me as part of this trend to minimize their work and thought and preparation for mediation versus what good mentoring I got back in the 1980s and 90s as counsel. You never wanted to miss an opportunity to advocate on behalf of your client. And then of course you've got the Adeshina problem that if you pass on that and you have an unhappy client at the end, there's no getting out of the responsibility you have, both under the case law and codes of conduct, to do more than what many counsel are now doing in mediations. I also make reference to what I've described as the strategic selection of mediators. So, and I see that particularly in the insurance realm where some insurers have some favorite mediators, and they have those favorites because they have certain expectations of what that mediator will deliver in terms of process, not a lot of tolerance for a lot of discussion or openness. And secondly, coming very quickly to a determination, which more often than not is quite conservative from the, which suits the defense side. So we've got these kind of practices arising as well. And then I tie that into my final bullet there, which is Hammer versus respectful persuasion. So those are the hammer term is quite often used, certainly in my travels in Western Canada, and that's the concept that many council and many institutional clients would prefer to have a mediator that will hopefully find on an evaluative basis something that's favorable to the defense side and hammer it away on the plaintiff side to get resolution. And I make reference to that versus the approach I've always embraced, which is respectful persuasion and inclusion. I'm constantly having lively debates with a number of my colleagues and a number of mediators about the fact that you get a lot more accomplished by showing respect and allowing time and space for input than trying to force anything on anyone. And besides all that, apart from it not being effective, it's entirely inappropriate. And it feeds right into the whole concept of quality justice that we should be ensuring as many people as possible have access to. So I then make a couple of points there near the bottom, and Natalie, we can go to the next slide. Jean, is there anything pressing that you think we could address from any of the registrants? You're on mute at the moment.
Hi, sorry. Yeah, I changed. I'm doing your slides now. So
Oh.
my mute was in a different spot. No, but one thing that I think is interesting, you have referred several times to joint sessions versus, non-joint sessions, or, at the beginning of mediations, or there's different levels of joint sessions. There's the meet and greet and make sure everybody is properly introduced and knows who's there, versus a more formal presentation by counsel for the parties. And, it's very different in different places around the world, was my observation on that, my thought.
Yeah, no, and I was anxious. I know our time is limited, but I was anxious to get some input from some of the folks that have joined us today about experiences and practices in other parts of the world, but that could fill a whole day, as could many of these slides. So I know we have to be efficient with our time, but generally speaking, Jean, what I do in my mediations is, we have a quick intro at the outset. Usually we're all assembled on a screen, and then I suggest, and everybody typically buys into it, private discussions, short, with each side in advance of a plenary session. And often I'm told at the outset, do we really have to have a plenary session? And I say, well, it's your process. But, in my experience, there's some value to at least a short joint opening session. And certainly based on my training and experience, having an opportunity not to present as you would in a courtroom, but as I will allude to later, in the language of mediation, the right tone and substance to an opening overview from your client's perspective in an opening session. So I tend to nudge people back to that. That used to be the practice. But at the end of the day, if they don't want to have an opening session, it's their process. But it's just one of the negative trends that I think has crept into our practice in mediation.
There is another question here. How do you recommend young lawyers deal with a mediator who wishes to set their own agenda or does not engage with the client? It's an interesting question.
Yeah, no, and that's bang on. I mean, that's all part of what I've been talking about here. So in a later slide, I talk about trust but verify, and I'll just touch on it now. Jean, you don't need to skip ahead to that slide. We'll get to it momentarily. But on a formal basis, I've now made myself available for consulting work related to mediation. But more importantly, I'm always available, as I've already alluded to in this presentation, for conversations about all of this. But in terms of how to deal with that situation, I've had that repeat itself many times, where there are a number of more junior counsel who have had a very proactive, typically a former judge. They're not too certain about that selection. They've never used him or her, but they've heard things that cause them worry. So what I've been urging them privately is when that happens, seek out a meeting with that mediator in advance of the mediation and make sure that that mediator understands what your expectations as counsel are. And then I often get the feedback, well, but he or she's a judge. How do I raise all that? And I say, of course, we owe an obligation to each other, whether we're former judges or just colleagues in the practice, to be respectful and to be civil. But there is nothing wrong, and the rules do change for our judges once they step off the bench and are operating in the private realm. So there's nothing wrong for a lawyer at any vintage to seek out a meeting with a mediator and very politely but firmly say, look, this is what I'm used to in a mediation. It's worked well in the past. You and I haven't worked together before. Is this something you can incorporate into your conduct of the mediation? And so that's what I encourage many to do, and they've been doing that. And on a similar note, and we can skip the slide once we get to it, but I often get asked about new players on the scene, and of course there are lots of them. It was only 5-6 years ago that there were 4 or 5 of us that were busy with mediation. Now it's 10, 12, 15 with another 30 or 40 that are trying to throw their hat in the ring. But I often get asked about the background of certain litigators that are trying their hand at mediation. And with some of them, I know, for example, that they have little or no trial experience. So of course, I always have to be constructive and positive, but I'll urge people, colleagues that ask me about it, well, why don't you ask about their trial experience? Because evaluative input seems to be on the upswing. And it's always struck me as odd that many counsel in mediations who I know have far more trial experience than the mediator that they have, put so much stock on the evaluative input of a mediator that has done very few, if any, trials. So I simply point that out to them on a constructive basis. Or I might even know, for example, that mediator is doing defense work for the insurer that appointed them or that wanted them to be a mediator. So of course, I don't call that conflict out, but I urge the person to go back and inquire of the mediator whether he or she perceives himself or herself to have any conflict, and that should flush it out. So these are just 2 examples where I enjoy being available for colleagues. I try, of course, to be respectful and positive with my input, but this is my way of giving back in a small way, certainly in the fish pond that I operate in, with respect to some of these practices that are less than ideal in mediation.
Ivan, there is another practice that somebody was put in the chat here that they're beginning to see in the US, and I've personally not seen this, but this particular gentleman has, attorneys who towards the end of the mediation want to dismiss their clients and be the sole people who structure, I'm reading here, the language and sign the mediated settlement agreement. This person is opining this is not good because the parties need to decide the language, be there till the end, and sign the MSA. Any thoughts or comments on that? Have you seen that in Canada?
No, I get occasionally asked about, and I've seen, right now I have a med arb on the go. An ex-judge took a shot at a mediation 2 years ago on it, and I came in to try and advance the yardsticks on the matter, but she had written up minutes of understanding or resolution, and that's a poor practice. Counsel will often ask me, will you summarize all this? And I prefer not. It should be in the wording of counsel and their clients. And then as for this practice, I don't always see, because sometimes it's done in the breakout rooms, but clients should be an integral part of it. Obviously, the lawyers know what kind of language makes sense and release documentation and things of that sort, but all of it should be reviewed in concert with the client. So, I think that's a bit of a risky practice. And it's one that, for a disgruntled client after the fact is more fodder for a lawsuit.
Well, and I would just add to that, that, I mean, if the mediator is involved in the drafting of that, then that's really the practice of law as opposed to mediation.
Yeah.
And my errors and omissions insurance, for example, specifically says you can't be involved in drafting the settlement agreement. You know, so anyway, shall we get on with your, or do you have other comments on that?
And I'm going to accelerate it because I see my time is starting to run down, so I'll be quicker now. But this slide here, I just wanted that up to just make this one point, that quite apart from the comments I've already shared about some less than desirable influences of certain mediators, we have this whole different layer in private mediation that adds so much color, satisfaction, fulfillment for the parties themselves. And that's nothing that the judges are used to when they're on the bench. And it's not something that they are wired generally to consider when they are serving as private mediators. So it's that whole level as described by this, the editor-in-chief of one of our very worthy journals here in Alberta, or Canada rather, about a higher form of justice. And a lot of what I've been talking about in terms of inclusiveness, not imposing anything, being respectful of the party's right to self-determination, both in process and outcome, it's all about this higher form of justice, which often gets forgotten in this day and age where more and more counsel are doing less and less work in preparation, and they're expecting the mediator to both tell them what the right answer is at some point in the mediation and dictate process. And this can't be forgotten, because this is a critical component which, in my experience, takes my respectful persuasion and that approach that I know many other thoughtful mediators bring, makes it far more effective in achieving results, far more than the hammer approach that I alluded to earlier. So next slide, Jean, please. Uh-oh, are you stuck too?
Yeah, here, hold on a second. Maybe I need to get that down. There we go.
Perfect. Importance of trust. There we go. You know what? Let's skip this. Not because it's not important, but our time is running short, and anybody who's interested in all this will get the full package anyway. This slide, the only point I'll make at this stage is it's circling back to some fundamental considerations, starting with the selecting of a mediator. We have some mediators in Alberta with very little experience who will openly tell me, I don't think who the mediator is very important. You know, I feel that vibe from many counsel, but when I start hearing it from aspiring mediators, I think, you know, that's really not a good sign. And then we have all the labels and styles. And for as long as I've been in the practice, there's been so much confusion amongst counsel and mediators, both aspiring and established, about what they really mean. And so I've just outlined them there, but then I talk about the one trick pony. And there's so many even experienced counsel and even mediators who say, well, I'm a facilitative mediator, or I'm an evaluative mediator. And it reminds me of my days in litigation where we referred to litigators who had just one speed as one trick ponies. And I've always been of the view, whether it's litigators or mediators, your obligation is to be, and you're most effective if you can transition as required by the circumstances in all aspects of the practice. And so on the next page, Jean, if you can just take us there, I'll leave this for everybody later, but Bernard Mayer, many of you will probably know that name. He's from the United States. He was a big influence on me when I was doing my master's program. Whatever I could read by him, I lapped up. But here is, and it's a long quote because it talks about all these aspects to mediation work, all of which goes to that comment I made somewhere in the slides about, you know, if you think this is an easy gig, you're not thinking it through hard enough. And so this talks about all the expectations and all the demands on a mediator. So read that in your leisure if you want these slides later. Jean, next slide. All right, so this is that trust but verify page. So I've already talked about most of this, but this is, you know, the start of my concluding message to most, if not all of you, which is these are all concepts that most of you are well familiar with, but I just urge all of us to serve more of a mentoring and education role so that some of these bad practices are offset by those of us that do bring more thought to this and are more considerate of all the underlying principles, give back and try and reverse some negative trends in the practice. So I already touched on most of that. Let's go on to the next 2 slides, Jean. All right, so I borrowed this from or I used it from a previous presentation, but for those of you that will ask for these slides and see it later, I've got 2 schematics. This first one, dynamics of mediation, it largely mirrors some considerations in the insurance context, which is about half my practice. The other half is just a real mishmash of corporate matters and estate matters and some family. But we don't have time to go through all this, except just take a look at that good faith definition, because I'm going to circle back to that with whatever minutes I have left. Next page, Jean.
We're there.
Oh, that's right. Okay. So, and this, in contrast to the other one, has some bubbles, as you can see. And this is what makes non-insurance matters more fun from a professional perspective, but also gives you more flexibility to canvas options. And so you'll see, and most of you will be aware of this, in corporate disputes, it's not just projecting what most judges on most days will do or negotiating in the shadow of the law, as many people refer to, but you've got the possibility of better future relationships, even between warring parties, tax considerations, goodwill, all of those considerations, which makes it easier for a mediator to explore options towards resolution. Okay, next, Jean. Now this, I don't have time to explore. Jean, do I have another 5 or so minutes?
You have 6 minutes.
6 minutes, all right. So this is a new slide. You know, I give these presentations periodically on variations on a theme, but this is, you'll see the title, Promoting Access to Quality Justice on a Micro Level. And you'll see reference to a no-fly list there, which is just, what do I describe it? Possible criteria. So I and many other mediators from my conversations are starting to get a little bit impatient with too many games being played, largely by the lawyers in mediations. And I had an interesting conversation with Jeff Chavin, who couldn't join us today. But I ran this idea past him, and his advice to me was, Ivan, if you're going to institute a no-fly list, of course, you've got to do it carefully. You don't want any negative pushback by declining retainers from people that you just don't think are approaching it on a consistent basis in a good faith fashion. If you have one of those, just don't make it too long, because it won't be good for business. So let's go to the next slide. And with the final few minutes I have, I do want to just focus on the AI concept here. And largely because this is, it encompasses what I describe often as the tech craze. And that feeds into the trust but verify. We have lots of worthy individuals with lots of experience, but a lot of passion and interest for tech that are promoting their services, and we've got big corporations behind many of them. And I've had this discussion with a number of colleagues here in Alberta about how the tech craze is seems to be going unchecked. For example, in the Law Society context, I've been monitoring some developments with the UK Law Society, with the Ontario Law Society, and you know the law societies. You know, I just caution about just embracing all of this technology, because it's being promoted as a way to enhance quality justice and access to quality justice. But as with everything in life, balance is what's important. So I raise it for that reason, but also I know one of my good friends from Toronto is joining us for this program, and he prepared for me a very helpful video clip, which you can find on my website. His name is Philip Hume. And in a very short clip, he describes very succinctly the limitations and capabilities of machine learning and AI for what lawyers do, whether it be mediators or counsel. And so I urge you to take a look at that clip and do some reading on it, because right now the tech craze seems to be gaining, in my view, too much traction. It's too out of whack in terms of easy solutions to problems that we as lawyers and mediators know isn't that easy. So just flip through the last couple of slides, Jean. The next one should be concluding considerations.
Do you want to skip this art one?
Yeah, you can just skip. This is just part of the AI.
Yeah, the algorithms thought these
Yeah,
people were
yeah.
naked. Yes. Okay.
Okay. There we go. Concluding considerations. I just urge you, to the extent any of what I've talked about resonates, regardless of how I've tried to express myself, this captures what my message is to all of you. Hopefully it resonates with a lot of you about just stepping up as thoughtful, experienced mediators to try and push back against some less than desirable trends in our practice. And then final slide, Jean. Here's recommended reading and resources. I've tried to make it fairly tight, but there are a couple in particular, and these are largely a mix of US and Canadian publications. Some of the authors, I'm sure all of you will recognize. Mnookin taught me at Harvard. And the 8th book is a recent publication, Mediation Ethics, which I'm now in the process of reading for a second time, but it's a fabulous book about how once and for all, we're going to try and match up to some degree the reality that we all face in practice versus a lot of the theoretical standards that have emanated both from academia and from some mediators. So I recommend that to everyone. If you happen to be one of the tech craze sorts, Beck's book on scatterbrain will explain to you why machines not now and likely not in the next foreseeable future can replace what we do in many of our functions, both as lawyers and as mediators. And of course, anything that Brené Brown writes, I recommend in terms of the psychological side to the dispute resolution process. And with that, Jean, I'm going to wrap things up because I think I'm out of time.
Okay, just one second here. I will put up your last page because that had your contact information on it. We've already shared that in the chat, but it's not going either. There you go.
There we go.
So here's how Ivan can be reached: website and his email address, phone number, and I think we're good then. There's so many other questions that were in the chat, and there were 2 others in particular and some wonderful comments. So we'll send those to you. And if you do want to reach out to Ivan directly, please feel free to do so. And thank you so much, Ivan.
Well, thank you for
Let me
the
stop the
opportunity.
share here. We'll go back to the regular squares. Thank you so much. And thank you everyone for being here and for your contributions to food banks around the world. Bye-bye. See you next week.